like to welcome everybody. Let me to stand. I'm too short to sit, and I don't feel comfortable to stand here, so I will stand in this place. Thank you for the invitation. As the organizers said, I'm working in the body of cultural autonomy of Hungarian national minority in Serbia as legal counselor on linguistic issues. And at the same time, I'm a professor assistant in a private law faculty in Novi Sad in constitutional and administrative law. The justification for this topic is given my PhD thesis that refers to separation of powers between different levels of state power with special focus on constitutional status and competences of Vojvodina. Last year I had the opportunity to cooperate with Mr. Salet in Flensburg when I was talking about dual autonomy of Vojvodina. In that time I gave special accent on national minority policy in Serbia. Today I would like to talk about role of territorial autonomy in national minority policy, and especially I would like to present you some examples, those parts of the Constitutional Court decision about competences of Vojvodina from 2012 that directly affect national minority policy. Before I begin, I would like to ask how many of my colleagues is from Serbia. And how many lawyers are here? Oh, okay. Because I would like to talk more about the legal issues of this problem, but okay, then I will concentrate on some other parts. So before I would try to give you an answer whether we have to broaden or narrow the role of territorial autonomy, national minority protection, I would like to provide a general overview about the Serbia's national minority policy. After that, a general overview about territorial autonomy, then about role of territorial autonomy in national minority protection, and of course, to present you some provisions of Constitutional Court decision. So, because there are not so many lawyers here, you have to know that Serbia's legal background of national minority regulation is very well elaborated. So almost every legal act has separate provision on national minority protection. The Constitution from 2006 contains separate part on national minority rights, including collective and individual rights. We have these bodies of cultural autonomy, the so-called national councils, where I am working. And of course, there is a list of linguistic and some other individual minority rights guaranteed not just by our constitution, but almost by every constitution in different countries in Europe. We are members of a big number of international conventions. Serbia has concluded bilateral agreements with neighboring countries about mutual respect and cooperation concerning coexistence of common national minorities. For example, we have such a bilateral agreement with Hungary, Romania, or Croatia. The most important law for my presentation today is fifth one, the law on establishing competencies of Vojvodina from 2009, and also law on national councils or on cultural autonomy from the same year. Of course, there are a lot of material laws regulating fields of cultural autonomy as education, use of language, culture, or media issues, and use of language in court proceedings, yes, regulated by procedural laws. But what is very important, yes, these provincial acts, the question is whether autonomous province of Vojvodina, what is situated in the north part of Serbia, can regulate national minority questions, if can, by which acts, whether provincial acts can, can be primer to these other laws, or whether are they on this equal footing with the governmental decrees in this question. I took the EU Commission report from 2010. There was a separate report last year about Serbia's application for membership, but that report from minority aspects was not so good for us. So this is the reason why I took the one from 2010. I would like to present you the statements of that report and also to add my personal comments. In 2010, maybe the basic statement about our national minority policy was this one, that the legal and policy framework for protection of minorities in Serbia is in line with the EU standards. As you can know, we do not have EU standards in national minority protection, so to see which are these standards by the Commission. I told you that minority protection is regulated by the Constitution. This column refers to the statements from the report. The problem is that these legal sources of minority protection are controversial. So, on one side, Constitution guarantees a right, on the other side, the governmental decree regulates a question totally differently. By the Commission, if a member state has ratified the Framework Convention and the European Language Charter, then it means that its national minority policy is in line with EU standards. Serbia is member in both agreements. Problem is that they are not applicable in practice. Let me provide an example. During my work in National Council, there was a special case that a guy has concluded a contract on Hungarian language in that municipality where Hungarian language was in official use in accordance with law, and the local state bodies did not accept the contract because it was on Hungarian language, and this is regulated just by the European Language Charter and not by state laws. So, because there are just one lawyer. So, if in the hierarchy of legal sources a question is regulated by international conventions that are ratified, then these rights has to be primarily applicable, notwithstanding whether that right is regulated by a state law or not. As I said, we have a special law on cultural autonomy. This is under constitutional review today, so in 2010 it was very welcome. Today it is under review. There are joint committees, intergovernmental committees with Hungary, for example, but they do not have any practical use, so unfortunately they are talking, but they do not do anything else. In 2010, there was a special ministry on human and minority rights in Serbia. In 2011, it has been transformed to a Ministry of Public Administration and Human and Minority Rights, and today there is just a council on minority issues. That council deals just with financing aspects of national councils, so there is no state body that deals directly with minority issues as such. I don't know anything about the Republican National Council, so I know that it exists, but what are the competencies, I don't know. During 8 years, today 10 years of existence, there were just 2 sessions. On the first session, they have adopted the rules of procedure. On the second one, they have determined what will be the salary of the Secretary of the National Council. But existence of such National Council was very welcome by the EU report. There are a lot of linguistic rights on paper. Yes, we have minority political parties, but they are not financed as they should. And also there are minority parties that are financed too much. Serbia has a separate Roma inclusion program. As Professor Varadis said, I would like to refer to his presentation. We cannot compare social economic inclusion problems with national minority protection in field of cultural autonomy. So it's very good that we have Roma inclusion problem, but what to do with other minorities, especially with those who are new minorities. After falling apart of Yugoslavia, those member states that were member states within Yugoslavia have become minorities in Serbia. For example, Montenegrinians still today do not declare themselves as national minorities. They don't have their national council in Serbia. Or, for example, Croatians, Slovenians, they have otherwise their national councils. So their position in Serbia is also not regulated, and it is a very big problem. And what is my topic today? The EU taught in 2010 that decentralization procedures are on good way. And the multicultural character of Vojvodina can help also inclusion of Serbia into the EU processes. Today we know that 22 provisions of the law on competencies of Vojvodina are unconstitutional. My topic today to show you which of these provisions affect directly national minorities in Serbia. This is a charter with data from 2011. This is the last census and the fresh data. Vojvodina is the last column, shows that 35% of the Vojvodinian population belongs to a minority. It means that the Vojvodina, the north part of Serbia, is the most heterogeneous part in ethnic sense. The biggest ones are Hungarians, but also Slovakians, Croatians, and the Roma group is very well represented. Central Serbia, in ethnic sense, is the most homogeneous. So you see just 10% belongs to a minority, and mostly to Bosnians and to Romans. You have to know that this ethnic structure is without Kosovo, so Albanians are in a very little number, you see. But almost 20% of the overall state population belongs to any minority. How it looks like in Vojvodina. This is Vojvodina, the north part of Serbia. The national minority usually lives near to border. So almost every big national minority, as Hungarians or their Romanians, live near to the border. So interregional cooperation and cross-border cooperation with Hungary or even with Romania and Croatia are the basis of national minority policy of the region in the future. It should be the basis. So, how it looks like in law, I will try not to be boring, but it will be very hard, but I will try. Serbia is a unitary state, so it has a unitary legal order. What it means? The normative power, the executive, the judicial power, everything belongs to the state. So there are just state laws, there are no provincial or regional laws. There is only one autonomous province by the constitution. This is Vojvodina, you could see. Kosovo has a special status by the constitution that should be regulated by separate law. This law has not been adopted still today, but I don't think so that it will be. So we have an asymmetrically decentralized legal order with just one province, and everything else will in sense of normative and executive activity belongs to the state. You cannot compare regions and provinces in Serbia. Autonomous province of Vojvodina has the legal and political personality, and this autonomy is justified because of historic, economic, cultural reasons. In case of regions, we talk about administrative units, so they have justification just because of economic sense. And also the constitution guarantees the right of citizens to territorial autonomy, even in form of provinces, even in form of local municipalities, to restrict the state power. The constitution enumerates taxatively in which social fields can Vojvodina regulate issues of provincial interest with its provincial bylaws. For example, sport, culture, education, forestry, industry, social, healthcare, and almost everything, traffic. In these social fields, Vojvodina can adopt some bylaws that implement state laws. So it means that the autonomy is very much restricted. So even it doesn't mean implementation by provincial acts, just implementation of governmental strategies, governmental bylaws or decrees, but not implementation of law in legal sense. Of course, there are transferred competencies. Their list is very long, but you know that transferred competence is under control of the state. When I talk about original competencies, then it means that Vojvodina is autonomous in sense of regulation of some social fields. And what is the most important, this fourth statement, the Constitution grants the right to Vojvodina or to provinces to regulate rights of minorities additionally to those that exist in the Constitution. So Vojvodina, I talk just about Vojvodina because now this is the only autonomous province and Kosovo should have a larger autonomy by the Constitution. So when I talk about Vojvodina or province, I think on one term. So the question is, in which fields can the province guarantee some additional rights to its minorities? The law on competencies of Vojvodina from 2009 talks about minority rights in 4 fields. In field of education, culture, mass media, and official use of language. In case of education, Vojvodina can adopt different textbooks, syllabi on minority languages, can form teaching aids devices, also can give consent whether to open a minority class or not. In field of culture, official use of language can add some additional rights by its regulations, and in case of media can support minority media houses financially. Also, Vojvodina has a special relation with national councils. National councils that have seats in Vojvodina are double financed. So they are financed from the state budget and also they are financed from the Vojvodinian budget. Also, Vojvodina as province can be co-founder with national councils in media houses, in schools, in theaters, in libraries, so they can share the founding rights. Also, Vojvodina can delegate some of its powers in field of cultural autonomy to national council. So all these competencies are regulated by that one law I mentioned, law on competencies of Vojvodina. So just to go back on this previous slide, everything that I mentioned now belongs to the first group, to original competencies by the Constitution. It should mean that Vojvodina autonomously regulate all these issues of provincial interest. The question is which law can regulate, whether this law on competencies, whether a law on education and to have separate part of minority questions, whether provincial acts are enough to regulate such questions. And also the big question, whether all these regulations by the province are in accordance with unitary legal order, because it means that those citizens who do not live in Vojvodina, persons belonging to a minority, do not enjoy such minority rights just because these rights are granted in territory of Vojvodina. So the question is whether Vojvodina's power to grant some additional rights in accordance with equality of citizens of Serbia in total. And yes, the Constitutional Court answer was that no. So Vojvodina, yes, can grant some rights, but these rights cannot be more than those rights guaranteed to other persons in central Serbia. The doctrinal decision of Constitutional Court stated that the centralization of Serbia is one of the main principles of our constitutional order. It is in line with our EU integration processes, but on the other side, the centralization in Serbia doesn't mean the centralization of the overall state power, just public administration, and not totally, just partially. So even when we talk about the centralization of public administration in the province, it doesn't mean that every aspect of public administration can be regulated by the province. And also in the fight, right to autonomy and equality of citizens won in this decision. In the next 4 slides, I would like to provide you practical examples. Maybe this presentation is not so understanding because it's legal, but maybe for a lawyer it's okay. It's okay. Okay. The first sentence is a provision from the law on competencies of Vojvodina. So it is an original competence. The first one, this is the first column, the proposal, was the challenge. Why they challenged the provision. The second one is the answer of the parliament. As I said, in Vojvodina, minorities live close to the border, so interregional cooperation is one of the most important devices of minority protection in this era. So Vojvodina shall conclude interregional agreements. The proposal states that hierarchy of legal sources doesn't recognize interregional agreements. So it says that there is just constitution, there are international conventions, there are laws, but interregional conventions or interregional agreements are unknown for our constitution. And also the question is whether they are devised of internal or international law, because interregional cooperation can be also within the state, not just within our state and with regions from another state. The parliament answered that we cannot imagine interregional cooperation without a legal act. So we cannot cooperate with somebody, especially from other states, when we do not have anything. Interregional agreements do not have to be legal acts. They can be political acts also. And yes, of course, they are international interregional agreements because Serbia is not a regionalized state. So we do not have regions in a legal sense, just in political and economic sense. And also I would like to add as personal comment that, for example, civil organizations can cooperate. They can conclude different partnerships. For example, football organization, they transfer their players from one municipality to another, from one state to another. These legal sources, because they are legal sources, they are not mentioned at all in the constitution, not just in the Serbian one, but in any constitution of the world. And they are, yes, part of the legal order. So interregional agreements can be part of the legal order. So thanks God the Constitutional Court accepted such reasoning, and this provision is still constitutional. The second one refers directly to minority rights. Autonomous province of Vojvodina can or shall regulate and ensure rights pertaining education in native language. What does it mean? The Constitution in the part on national minorities says that minorities have right to schooling. Not right to education, but right to schooling. And the proposal states that right to schooling is not right to education. Schooling contains primary and high school, but not kindergarten and university. The parliament states that because Vojvodina has right to additionally regulate some minority rights, it can even regulate university education on minority languages. Schooling and education, I think, not just in the Serbian, Hungarian or in English are very similar terms, but I think that their relation is not clear at all in any languages. Also, what is very important that Vojvodina has competencies in 4 levels of education. So it doesn't mean that we have university education on Hungarian, Slovakian, and any other languages, but we can have if there is opportunity for that. But we do not have professors, we do not have so many students to learn on that languages. So the Constitutional Court accepted the Parliament's answer and stated that yes, the Constitution means that in this case Vojvodina can guarantee additional rights. So this is again a constitutional provision. At first sight, what network of courts does with minority policy? A lot. Vojvodina, by this law on competency, shall propose the network of courts. If you remember on the ethnic map of Vojvodina, so we can draw the borders of courts like that there will be always majority of one national group. So there will be no judges who can conduct proceedings on minority languages, or there will be no judges who can even speak minority languages, and this will breach directly right to minorities to use their language in civil, in court proceedings. So this was the reason why this provision has somehow effect on minority policy. The proposal states that network of courts should be regulated by separate law on courts. Also, they didn't understand what provincial territory does with distribution of courts, and also this territorial autonomy is not judicial autonomy. The parliament's answer was very bad. It was very bad. It states that the proposal in law is not obligatory. Yes, it's not obligatory, so we can propose everything we want. My answer is that by the constitution, Vojvodina can initiate laws. It is a constitutional right to Vojvodina, can initiate even laws on courts, can also propose amendments on different laws. So, for example, Vojvodina can initiate a network of courts to change the network of courts in a separate law. It should be a good reasoning, but not this, that the proposal is not obligatory. The Constitutional Court did not accept it, so this is an unconstitutional provision today. And the last example, my research field, official use of language. Vojvodina has right to regulate the official use of language and script of minorities in the territory of Vojvodina. There are 6 minority languages, including Serbian Cyrillic and Serbian Latin, that are in official use in the work of provincial bodies. So it means that the overall communication can be on one of these languages. The proposal states that the constitution has a separate provision that the Serbian language and Cyrillic script is in official use, and everything else should be regulated by separate law on official use of languages. The parliament again refers to this opportunity to grant additional rights to minorities, and maybe you remember at education it was also the answer. So why not schooling and why education? Vojvodina stated because we have right to grant additional rights, and the Constitutional Court accepted. I don't know where I am. This time the answer was again the same. We have opportunity to grant additional rights, but this time the Constitutional Court didn't accept the reasoning. So this provision is unconstitutional by the Constitutional Court, even though the reasoning was the same. So if I would be asked whether is role of territorial autonomy in field of national minority protection is broadened or narrowed, I cannot answer, because in some parts it's narrowed, in some parts it's broadened by the Constitutional Court. And because I am in the end of my time, I have to conclude that decentralization is interpreted very much restrictively, not just in legal sense, but also in financing and also in political sense. Today, as you could see, law on national councils is under constitutionality review, so maybe the results of this review will directly affect also the role of Vojvodina in national minority protection, and of course, possible future status of Kosovo, because a lot of researchers think that somehow status of Vojvodina and status of Kosovo are linked. I personally think that they are not linked, but maybe amendments of constitution because of status of Kosovo will directly affect also territorial autonomy in Vojvodina, and of course our way to the European Union, whether Serbia will remain on the old road or not. It will very much affect it. Vojvodina's status. So I'm really sorry that I couldn't provide answers, just question marks, but I think that our research is okay and we will have work until we have questions, and when we will have just answers, it means that our work is done. So, thank you.